And I like to start on time. Welcome everyone. On behalf of the San Mateo Area Chamber of Commerce, I'd like to welcome you to our webinar series. And we are very fortunate today to have Jeff Windsor of Windsor Inc., an attorney and quite an impressive resume. You can check it out online. And he's going to talk about business disputes and how to mediate them during this very difficult time. So it's not always the most pleasant topic, but it's a very important topic. So with that, Jeff, take it away.
Good morning, everyone. Thank you for joining me for this discussion. First, let me say that I hope everyone is healthy physically and mentally and engaging in all appropriate social behavior, including staying in place and physical distancing. I'm pretty eager to get back out into the world and as close to normal as possible, but we're going to be living in a new normal for, I think, the rest of our lives. And for our own sakes and the collective good, we should be adapting to the healthiest measures possible. Second, I've prepared a lot of material and I'm going to try to get through as much of it as possible. I should say at the outset that what I am imparting to you here is not legal advice and should not be construed as such. However, I will be discussing certain areas of the law that I think are going to be important for businesses of all sizes and attorneys for the foreseeable future. Important word, foreseeable. If you are a business or property owner and you have any questions about anything that I've discussed here today, I'm happy to talk with you about your situation after this meeting, or I encourage you to contact your attorney if you already have one. I believe this is being recorded, so I think you'll be able to go back and reference items that I'm going to be talking about, and it's all public record in one format or another. But again, if you would like to discuss it, I'll answer some questions at the end and also give you my contact information. So I've prepared a slide and let me get started with that. So, in early March, I received a call from a client who, as part of their services, hold conferences around the world. They had two conferences coming up in April and July in the Bay Area and were asking me what they should do. By that time, Santa Clara County had reduced the size of gatherings to 1,000 people. Also at that time, a colleague of mine asked about a situation that he had with a client. He represented a seller of a condo in San Francisco that had gone into contract in February. The buyer was looking to back out because of COVID-19 and the state of the markets. On March 9th, the Dow Jones Industrial Average had lost more than 2,000 points and the S&P 500 fell 7.6%. Between March 9th and March 16th, the markets had their three worst drops in US history. Governor Newsom had told Californians to cancel or postpone events of more than 250 people. On March 16th, Dr. Scott Morrow, the health officer in San Mateo County, issued the shelter-in-place order, and similar orders were issued throughout all of the Bay Area. That same day, Governor Newsom ordered the suspension of residential evictions for failure to pay rent to May 31st and gave local governments discretion in the enforcement of unlawful detainer actions for that same period in order to, among other things, promote housing and stability. And that was Executive Order N-2820. Governor Newsom then, on March 19th, issued a statewide order, shelter-in-place order N-3320, which most of you know has been extended by the counties until the end of the month. On April 7th, the San Mateo County Board of Supervisors adopted Urgency Ordinance number 4826. As it relates to commercial property, the order is a moratorium on the eviction of commercial tenants with gross receipts of $2.5 million or less for the non-payment of rent. The moratorium is in effect until at least May 31st and can be extended. Moratorium is like a stay, a brief prohibition in which something can be done. Under the moratorium, an owner of commercial property cannot recover possession from a commercial tenant for failure to pay rent when it is due if the tenant can demonstrate the failure to pay was directly related to a decrease in net business income that result from the COVID-19 pandemic or any federal, state, or local government response. Now, Urgency Ordinance number 4826 has specific steps that both the owner and the tenant are required to comply with, including each putting the other on notice regarding their respective qualifications and applicability under the notice. I'm not going to go into all of the details regarding the urgency ordinance or those steps in this discussion. I or another attorney can talk with you about it later. There are very specific notice requirements and timelines involved, especially those that are triggered after the SIP is lifted. If you are either an owner of commercial property with tenants or a commercial tenant, or if you're an attorney that works in this space, you should read it carefully. Just as an example of this issue operating on a larger scale, Subway, Staples, Petco, The Gap, these and other retailers have all said they're going to stop paying rent. Last I read, over 50,000 chain retail locations are closed. Humbly, I think this is a harbinger. Where does this lead us? Generally, to at least 3 areas of law that may apply: force majeure, impossibility and impracticability, and commercial frustration of purpose. Before I start talking about those areas of the law, the very first thing that you do is look at the contract. What does the contract say? And among the many provisions in the contract that you should be looking for, 2 are important for these analyses. First, is there a provision related to force majeure or impossibility or its legal progeny, impracticability? Second, is there an application of law or venue provision? If there is some kind of conflict, that provision may set out the law that applies. For our purposes here, I'm going to generally refer to California law. However, if you are contracting for goods or services, that agreement might call out the law of a different venue. You'll need to know what that is. Another reason that you want to know what the applicable law is because if you are required to comply with the law of a specific jurisdiction, that jurisdiction's mandates will have an effect on whether you can perform the contract. So again, in California, and more specifically here in San Mateo County, there are stay in place orders in effect. If a contract provision requires to follow a government regulation or restriction, such as an SIP, you may not be able to perform pursuant to one of the legal theories that I'll discuss in a moment. Also related to this is we have now the government restriction may set out essential and non-essential businesses or workers. This is very important to the analysis and the other concepts that we're discussing. Whether your business is considered essential or non-essential, how do you know? One place that may provide guidance is the state public health officer's list of essential critical infrastructure workers, and I've provided the address for the link. As of April 28th, that 23-page list included commercial sectors with descriptions of businesses and workers in those sectors. A sample of those sectors are healthcare and public health, emergency services, energy, transportation, and other community-based government operations and essential functions. And there are links at the end of that list to provide additional specific sector guidance. San Mateo County on April 29th also modified the definition of essential business, and the regulations related to those businesses were also further modified. For that, you should see the San Mateo County Health website. With these factors in mind, we can begin looking at the legal theories that I listed. First, force majeure. It's a French term that, according to Merriam-Webster and my wife, who has had many years of French, means superior force. In the context of contracts, it is usually referred to in a specific provision in a contract that may allow for the termination or suspension of performance because of the occurrence of a significant supervening event which is out of the party's control. In California, it is referred to at Civil Code Section 1511, subsection 2, and something else that may also provide guidance is Civil Code Section 3526. Some see these two provisions as California taking a more liberal view of what is a force majeure, and that courts may interpret such provisions accordingly. Now, here again, it is very important to look at what the contract says. Typically, when a force majeure provision is in a contract, there is often a list of conceived events to which it may apply. For example, war, terrorist attacks, strikes, natural disasters, or acts of God. An earthquake or a tsunami might be another example. Also, it's important to see if there are any time issues related to the force majeure event. For instance, whether performance can be delayed for 60 to 90 days for such an event, or whether the contract can be terminated outright. I read recently that the governor of Oklahoma asked that President Trump declare that COVID-19 was an act of God so that oil companies could get out of their own contracts. Just an observation, and I think a funny little bit of irony, whether something is an act of God is a question for the jury. But I've also looked, and I haven't found a KC jury instruction on the issue yet. Often, when there is a force majeure provision in a contract, there is a list of potential qualifying events, like I just read. However, many do not include an illness or pandemic. You or your attorneys may now want to change that. Excuse me. On the flip side, however, many force majeure provisions do include governmental regulations or restrictions, like perhaps orders to shelter in place or travel restrictions. Generally speaking, a force majeure event is an event that is not anticipated or reasonably foreseeable, could not be prevented by the parties, and directly caused the failure to meet their contractual obligations. Next, impossibility and impracticability. Excuse me. Impossibility is a common law defense to the performance of a contract. It is referenced in Civil Code Section 1441. Originally, it was based on a literal or physical impossibility to perform. Over time, the concept is broadened. Now something can be considered legally impossible when it is impracticable. Something is impracticable when it can be done only at excessive or an unreasonable difficulty or expense. However, it is not based on a party's inability to perform. Unusual or unexpected expenses do not establish impossibility. Something that makes performance more difficult or costly than the parties originally considered when entering into the agreement also don't establish impossibility. The question is the degree to which the expense is unreasonable or excessive. An important question is the nature of the contract. A good example here may be a concert or conferences like my client holds. If because a municipality orders that gatherings over 100 people are prohibited, it may be considered legally impossible, that is, impracticable, to hold it. The expense could be excessive if, for instance, only 100 people could attend. The South by Southwest Festival was canceled for that reason, and this was one of the things that I discussed with my clients in relation to their conferences. Excuse me. In the case of South by Southwest and similar events, there's often cancellation insurance. However, some cancellation insurance policies don't include automatic coverage for a pandemic, or for an epidemic rather. The South by Southwest concert policy didn't include an epidemic rider. Thus, the carrier there will argue that there isn't coverage. On the flip side of that, an attorney might argue this is a pandemic, not an epidemic. An epidemic is usually contained within a community. A pandemic spreads across countries. I'm not entirely sure what the policy says in that case, but I'm sure the handling attorneys will be discussing it for a while. The point being, it's impracticable to proceed with the concert, so should be considered legally impossible. Another recent example regarding impossibility that I saw at the beginning of April, a case was filed down in LA regarding the purchase of commercial development property where the buyer asserts, among other things, that it would be a crime to try to finalize the purchase because the buyer couldn't physically attend the close. California applies an objective test to assessing legal impossibility. If what is agreed to be done is possible and lawful, it must be done. If a party can perform and in consideration of all circumstances, it is not impossible and that party does not perform, they're in breach. The last legal theory that I want to discuss is commercial frustration of purpose, where a not reasonably foreseeable supervening event totally or near totally destroys the value of performance in a contract or lease. In law school, we learned this theory through a case, Clara versus Henry, which was about the coronation of King Edward VII. A gentleman, Henry, rented a flat for the purpose of watching the procession of the coronation of King Edward VII. Apparently the flat had a great view. Unfortunately, however, the king became ill, needed surgery, and the coronation was postponed. The court held that the purpose for entering into the agreement became frustrated by an unforeseeable event, the illness and surgery. There would be no coronation to watch, which was the reason Henry rented the flat. Because the purpose for renting the flat became frustrated, he didn't have to pay. Many companies are going to assert this defense. Another point I think to keep in mind in all of this, we keep hearing this is unprecedented. COVID-19 and all of its repercussions, especially economic. We've never seen anything like this before. The common law theories that I just described are based on precedent. Courts will be applying case law decided at times that we have seen only in a limited context, such as World War II or other profound events in human history. Our judges are very smart, capable people. However, these are enormous issues with trillions of dollars at stake that we have never seen in our lifetime. These are not going to be easy decisions. They're all very fact intensive and may not be as clear cut as you think. At least two other provisions that you'll want to look for in your contracts, and you may want to consider including in your contracts going forward, a dispute resolution provision, and there are at least two forms of alternative dispute resolution that may be called out in your contract or that you may want to include, arbitration or mediation. Before filing a civil action, your contract may require to engage in at least one of these forms of ADR, which I'll discuss later. And in light of where we are today, you may want to make sure they're included. A prevailing parties provision with an attorney's fees kicker. Generally speaking, what this means is that if there is a dispute and there is a civil action or arbitration, the prevailing party can potentially be awarded their costs and fees, but there should also be a specific call out for attorney's fees. Again, this is something that you should discuss with an attorney. It's also worth noting that the California Association of Realtors has already prepared forms related to closing or not because of COVID-19 and regarding the ability or inability to pay rent. Again, practitioners that work in these areas should look up these forms. Other issues that will likely be in dispute relate to insurance. Business interruption insurance covers lost income after a business suffers a disaster for a limited period of time. However, it often only kicks in when there is physical damage to insured property for a covered peril resulting in the business interruption. This raises additional questions, not the least of which is whether the coronavirus being on the physical property, if it is detected, can be considered physical damage. Firms are already advertising to file class action lawsuits related to the denial of business interruption insurance. Cancellation insurance is something that I've already briefly touched on and also applies in the context of travel. And commercial general liability, workers' compensation, and D&O policies will also be implicated as they relate to bodily injury from exposure to COVID-19. These claims, of course, will also include claims for pain and suffering and emotional distress, and there will be issues about a failure to provide adequate protection. There will be many of these cases, and there will be many issues related to insurance coverage. Getting back to a little more context. On March 23rd, Chief Justice Tani Kantil Sakaue ordered that all civil trials automatically be continued for 60 days. On March 27th, because of all these conditions, the Honorable Judge Nancy Feynman in San Mateo County Superior Court ordered that law and motion matters from March 17 to May 21st will not be heard. On April 1st, the presiding judge, the Honorable Judge Jonathan Karish, ordered that all trials would be suspended until at least May 21st. On May 1st, Friday, Honorable Judge Marie Weiner and Judge Feynman issued orders regarding procedures for discovery disputes for motions that have already been filed. Excuse me. And as we sit here today, in essence, for non-emergency purposes, the courthouse is closed. Subject to different timelines, courts throughout the state and country are closed. Many of you now have or will have some kind of contract or lease dispute. With all that I've just provided to you in the background, it's my belief that it is going to be a very long time before a court hears your contract dispute, either as a bench trial or jury trial, but it will be an especially long time before the court hears it as a civil jury trial. At the moment, we don't have guidelines regarding physical distancing at large gatherings. In order to impanel a jury, it can take dozens of people to be summoned to a courthouse, gather, sit together, and then for the attorneys and judges to agree that the people sitting in the box will be on the jury, and that particular trial will last approximately a week, probably more. People are going to be very reluctant to enter such an environment, and they will probably make a lot of effort to not be on a jury. I'm not advocating that. but that's just one of the things that I believe about people and human nature. In addition to the myriad of issues that we're going to be facing in the future, what I've just described is going to present a considerable challenge for our judicial system. Our justices and judges are working right now to try to figure out how to manage what will be an anticipated backlog. And just like so many of us in what will be our new economy, the judicial system will also face budget issues. What I believe is a potential contribution to the solution is mediation. Mediation is a forum in which a third-party neutral works with the parties to help resolve the dispute, settle the case. It can be done by Zoom, just like we're doing here, or another video platform. You and your attorneys can be placed in separate breakout rooms to discuss your case, and nobody will hear your discussion. I know people have heard about Zoom bombing and privacy issues, and special settings can ensure that all of the discussions are private and confidential. And documents such as your contracts and leases can be shared over email or online drives. It can also be done over the phone, especially where you have multiple parties. For example, if there are contractors, subcontractors, insurance adjusters at different locations around the country. A mediator does not render a decision on anyone's behalf. A mediator helps the parties try to reach an acceptable compromise. He or she may provide an opinion or evaluation along the way, but ultimately the parties involved are the ones that decide whether to accept a potential offer that's on the table. If they do, the parties can move on and get back to business. If they don't, they may still need to litigate their conflict. Arbitration is also a potential dispute resolution forum that you can engage in. It is much like a mini trial in which evidence is presented and witnesses are called. It can also take place by video and may happen sooner than if the parties went through the courts. At the end of it, a decision is rendered by the arbitrator or arbitrators, and that decision may or may not be binding. However, you will still need to go through the process of taking depositions and exchanging evidence. And if it is not binding, then you may end up still needing to file a civil action. You may be able to resolve the matter with the other party on your own. I'm sure many would agree with me in saying this, and that is, do your best to try to resolve the matter between the two of you. Be as reasonable as you can and make every effort to let cooler heads prevail. This may include discounting rent, deferring rent, discounting products, or service providers working off some of what may be owed. I was in a Zoom meeting last Friday where one of the presenters, a real estate professional, said that approximately 30% of their
He's got a COVID. He froze.
leasing had stopped, and there was, at least in San Francisco in 2018, 34% of the taxes and fees that the city received were from small businesses, which they defined as $30 million or less. And there are now estimates that nearly half of the restaurants in the city will close. They project losing $1.7 billion in revenue over the next 2 years, and 1 out of every 6 people will be unemployed. I think now, perhaps more than any time in human history, certainly our history, we need to genuinely work together to solve problems and create solutions. If for some reason you're not able to do that, then you'll likely need a third party to work with you and the other party or parties to help try to settle your case, your dispute. As I said, fortunately, this can be done just as we're having this meeting here, online and through video. You don't have to physically put your health at risk or risk the health of others. Mediating by video and phone is something I and other practitioners can do. We have lost most of the generation that helped our country, and really humanity, prevail in World War II. This is a different kind of fight, which itself gives rise to a potentially overwhelming panoply of conflicts, which include the commercial disputes that some of you may now be engaged in. These disputes and cases will need to get settled. The sooner the better, for you individually and for our economy in general. I think you will need to find someone who will listen to your interests and concerns, will help you create solutions, and will help your businesses and your clients productively move on. Thank you for your time. Now, if there are any questions, I'm happy to answer them.
Thank you, Jeff. We have time maybe for a couple of questions. If you have one, please put it in the chat box. Pauline will unmute you so you can ask the question. Pauline, are there any?
There are no questions in the chat.
Okay. If you have something that you would like to discuss with Jeff, you can contact him. And tomorrow we are also having a webinar at 10 a.m. with another attorney. I guess it's Attorney Week. Angel Riley from Cheval & Glatt will talk about the importance of having a trust. Everyone in California needs a trust and should have one. So hope to see you tomorrow at 10. Have a great day, and we will see you soon. Oh, wait, let's see, we've got one. Oh.
Is this recorded? Yes, it is recorded. And we'll post it on our YouTube channel.
And as long as you're registered, we send that out to you as well. So that's why we asked for the registration. We would like to get you the documents and the video after the meeting. With that, I guess we are finished. Thank you very much, Jeff. That was very informative. And oh, someone just said, great job, Jeff. Okay, so have a great afternoon, and we will see you tomorrow, hopefully. Take care. Bye-bye.
Thank you.